Well, Mr. McLeod, it's alleged that you are in contempt of court for failing to appear on July 9th at 9:30 a.m. for a 50-day circuit court hearing. You've got the right to a hearing on that allegation where it would need to be proven beyond a reasonable doubt, and the right to the assistance of an attorney at that hearing. If you are found to be in violation, if you are found to be in contempt, I could jail you for up to 93 days. I could fine you for up to $7,500 or both. I can also revoke your bond if you're not complying with the terms of your release. Do you understand the rights and penalties that you have in front of you, Mr. McLeod?
Sure. I was under the impression that this was all going to be over with by now that we're
Nope.
in
Nope.
agreement.
All right, Mr. McLeod, and also, so you know the rights and penalties that I outlined for you. You understand those?
Yeah.
All right, Mr. Varga, do you know how you wishes to proceed?
No, he indicated he would enter his own plea.
Mr. McLeod, you're indicating you want to represent yourself?
Well, I thought that can I say a couple things first?
No.
Okay.
You can answer my questions.
Sure.
Are you saying you want to represent yourself?
They have been doing that the whole time.
You've been doing that the whole time. Under Ferretta v. California, 1975, U.S. Supreme Court, defendant has the constitutional right to represent himself. He has, in this case, unequivocally asserted that right in prior hearings and validly waived his right to counsel.
Hold up. Did you catch that? McLoud just confirmed he's been representing himself the whole time. Now watch what happens next, because this judge is about to drop some serious legal knowledge. The judge knows the law inside and out, citing Ferretta versus California and People versus Anderson. But here's the kicker. Self-representation isn't an absolute right. You can lose it if you abuse the court system. And folks, McLoud is about to find out exactly what that means. The judge is setting him up for one of the most brutal legal takedowns we've seen. Pay attention to how methodically the judge builds his case.
However, self-representation may be denied where the defendant disrupts, unduly inconveniences, or burdens the court and the administration of the court's business. That's 1976, Michigan Supreme Court, People v. Anderson. Even the Ferretta case, the U.S. Supreme Court said the right of self-representation is not a license to abuse the dignity of the courtroom. Neither is it a license not to comply with the relevant rules of procedural and substantive law. Here, while representing himself, defendant refused to accept mail from the clerk's office. When that happened, I directed staff to resend the mailing directly from the court, giving him the benefit of the doubt. Because he was representing himself, he would surely accept something from the court. He again refused, writing in red lettering on the envelope, return to sender, and offer to contract is denied.
Wait, what? He wrote, return to sender, and contract is denied in red letters on court mail? This is classic sovereign citizen behavior. Folks, they believe they can reject the court's authority by refusing mail, as if the legal system is some kind of opt-in subscription service. Newsflash, it's not. The judge even gave him a second chance by sending it directly from court. But McLoud doubled down on the crazy. And it gets worse. Wait until you hear what else he filed with the court. This is where things go from bad to absolutely insane.
Defendant had someone file a document on his behalf in his case called a letter rogatory for relief, which was legal nonsense, accusing the court of fraudulently using this case as some sort of security against his trust, claiming that all judges are foreign agents and or employees of the International Monetary Fund, which is absolutely absurd, and demanding that he be placed on some non-existent do not detain list. This is not the first time that this defendant has disrupted this court's business. One time I had to hold Mr. McLeod in contempt for refusing to answer my questions during his initial waiver of counsel. After that contempt, we were able to complete the waiver process and I allowed him to represent himself. But at those subsequent hearings, he repeatedly interrupted the proceedings. He repeatedly persisted in arguments, even after being heard and ruled against. And now he has refused to participate in the court process by rejecting court mailings while purporting to represent himself. So I have now lost any confidence, Mr. McLeod, that you are able to represent yourself in this matter without disrupting the court's business or making a mockery of the court proceedings. Therefore, as this case moves forward, I am revoking your right to represent yourself, and I'm appointing Mr. Virgo to represent you as a lawyer.
Okay, Mr. Virgo.
Boom. There it is. The judge just revoked his right to self-representation. Do you understand how rare this is? Courts bend over backwards to protect a defendant's right to represent themselves. But McLoud pushed it too far. Foreign agents, International Monetary Fund, a do not detain list. This judge has clearly dealt with sovereign citizens before, and he's not having any of it. And notice how he's been documenting everything. This isn't a snap decision. This is calculated, methodical, and completely justified. McLoud played stupid games, and now he's about to win stupid prizes.
Mr. Word over here.
If the Office of Assigned Counsel determines that Mr. McLoud is not indigent or is only partially indigent, that office may petition this court under the applicable statute for contribution from Mr. McLeod for the cost of representation. So, Mr. Varga, you want us to set this for a hearing then?
I do.
All right,
We're not guilty.
all right, Mr. McLeod will enter a plea of not guilty on your behalf as to the contempt. So we have to schedule this for a docket call on the underlying case, which is still pending, and on the contempt hearing. I'll schedule that for August 20th at 10 a.m. I also have to advise you, Mr. McLeod, that I canceled your jury trial date and gave that date to somebody else who was here. So your trial on August 8th and 9th will not occur. I will next see you on August 20th at 10 a.m. Anything as to release Mr. Varga?
Is the court willing to entertain a bond on this matter, Your Honor? To my understanding, Mr. McLeod is a local resident and he has met, with the exception of the last court date that he tells me that he thought the case was resolved, although obviously it was not. He has appeared for most of his prior court dates. All. Okay. And he's employed locally, Your Honor. I think perhaps if the court would set a modest monetary bond, that would ensure future.
I will not have to do. I assure you.
Mr. Juliet?
And I would ask that bond remain revoked. He is, what I'm told, rejecting the court's mailings of the notice to appear. I mean, I think that's just a blatant violation of
Can I speak on that?
the court rule. So he's made it clear he doesn't want to take this serious. I would ask that bond remain revoked.
All right, Mr. McLeod, is there something you wanted to tell me?
I wanted to speak on that, the mailing stuff. I do that with all my junk mail, and I'm really sorry if that happened to one of your letters.
No, he didn't. Did McLeod really just try to claim he thought court documents were junk mail after writing contract is denied in red letters? This is a legal equivalent of getting caught with your hand in the cookie jar and claiming you were just checking the temperature. The judge is about to call him out hard on this lie. Watch how quickly this excuse falls apart. You can almost feel the judge's patience evaporating in real time. This is what desperation looks like. Folks,
Don't make it worse by lying to me right now, Mr. McLeod. You wrote clear things on that mailing that indicate sovereign citizen types of defenses that you thought you were asserting. It's not that this was junk mail. Don't make it worse. Don't make it worse by lying.
I apologize to you for maybe listening to some of the wrong information when I don't.
Well, you're a grown person, Mr. McLeod, and I hope you're learning an important lesson in civics.
Can I just say this?
You said what you wanted to say.
Before you make your decision, can I say this? I have a job right now that's completely exposed to the weather. I've got $40,000 worth of windows coming this week to this job. I really invested in this job, and my client really rely on me. This would be a really big problem if I get this revoked.
and there it is, the moment reality hits. McLoud suddenly realizes his sovereign citizen games have real-world consequences. $40,000 worth of windows, a weather-dependent job. Now he wants to play by the rules? This is the same guy who claimed judges are foreign agents. Notice how quickly the tough guy's sovereign citizen act crumbles when jail becomes a real possibility. But it's too late. The judge gave him multiple chances. He rejected court mail, filed conspiracy theories, and disrupted proceedings. Do you think the judge will show mercy? Let's find out.
At this stage.
All right, well, Mr. McLeod, it's a shame you had to learn a civics lesson the hard way here. You are a citizen with rights and freedoms, but you also have responsibilities in a society where other citizens live alongside you. That includes obeying the laws that the people pass through their representatives. For example, the people are entitled to pass a law that says they don't want folks operating boats under the influence of alcohol. You think that law doesn't apply? It does.
That wasn't.
And when a law enforcement officer sees you violating that law, You can't resist arrest without consequence. When you are alleged to violate those laws, Mr. McLoud, there's a third branch of government that does exist. And it exists for the orderly resolution of those disputes, those allegations, with full protection of your rights, as opposed to some kind of vigilante justice system. You may not agree with this, but this court has diligently tried to protect your rights and afforded you a respectful and lawful process. You have disrupted and ignored that process. You have disrespected that process time and again. That subjects you now to contempt of court and revocation of bond. Most people, Mr. McLoud, learn this lesson the easy way, but it seems that you now have to learn it the hard way. You're remanded into custody of the Chagrin County Sheriff.
Remanded into custody. The gavel drops, and McLeod's sovereign citizen fantasy comes crashing down. This judge just delivered a masterclass in judicial patience and constitutional law. He didn't just punish McLeod, he educated him on how society actually works. Rights come with responsibilities. The court system exists to protect everyone, not just those who choose to recognize it. And that $40,000 window job, gone. His freedom, gone. All because he thought he could outsmart the system with internet conspiracy theories. This is why you don't take legal advice from sovereign citizen YouTube videos.
Folks. Sure. And will next see you, sir, with your lawyer, Mr. Wordbell, on August 20th at 10 a.m.
So, well, can I recess?
So what did we just witness? A defendant who started with a simple contempt charge for missing a court date ended up in jail because he bought into sovereign citizen nonsense. He refused court mail, claimed judges were foreign agents, demanded be on imaginary lists, and tried to treat the legal system like it was optional. The judge, showing incredible restraint, revoked his self-representation rights and ultimately his bond. The lesson? The law applies to everyone, whether you believe in it or not. McLoud lost his freedom, his job, and learned that rejecting reality doesn't change it. If you found this case as jaw-dropping as we did, make sure to hit that like button. Share your thoughts in the comments. Did the judge go too far, or was this justified? And don't forget to subscribe and hit the notification bell for more incredible courtroom breakdowns where sovereign citizens meet reality.